Good morning, everybody. Looks like we've got a pretty good turnout. If things get too crowded in here, I may ask the Capitol Police to clear out some of the folks. But as long as everybody can maintain, and then we can go ahead and proceed with the group that we have in here. What we're going to be doing today is we're going to be talking about an amendment that was made to a House bill last week. And that House bill was House Bill 658. And the amendment language, and I'll read it here. Notwithstanding any other provision of law to the contrary, the Division of Medicaid shall not execute a contract or make capitated payments for services provided under this subsection H with any entity which has executed a settlement agreement with the state of Mississippi or any other state to repay over $50 million related to allegations of fraud, waste, abuse, or overpayments in the state's Medicaid program. In addition to the managed care entities with which the division has contracted as of January 1st, 2022 to provide Medicaid services on a capitated basis under a managed care program or coordinated care program implemented by the division under this subsection H, the division shall select a Mississippi not-for-profit corporation to provide Medicaid services on a capitated basis under this subsection H. So with that, we have one witness, I think, that we're going to talk to today, and that's Drew Snyder, who's the Executive Director of Medicaid. Mr. Snyder, if you would take the podium and please give us your presentation.
Appreciate you organizing this public hearing. In a government program as complex and as expensive as Medicaid, any reform requires thoughtful consideration. I appreciate the Senate committee's engagement and your willingness to seek input from the people entrusted with administering the program. The first thing I want to do is clear up a statement that was made last week during the floor debate on House Bill 658. When Chairman Hood stepped up and opposed Chairman Curry's amendment to House Bill 658, Chairman Curry responded by saying a contract between Centene and Medicaid was, quote, going to be signed in March, and if we don't do it today, we're in for another 3 to 5 years with this company. That statement is simply untrue. Now, I'm here to tell you, where we actually are in the contracting process. We are in the midst of a competitive procurement process to award contracts to at least 2, but no more than 3 managed care contractors to administer the Mississippi CAN and Mississippi CHIP programs. Once selected, these contractors would start operations under the contract in 2023. Proposals by prospective vendors are due in about 3 weeks. So nearly 5 years ago, the division contracted with 3 vendors to administer the Mississippi Coordinated Access Network, or Mississippi CAN. Mississippi CAN is the bigger contract with 400,000 or so Medicaid members. It includes non-disabled children, foster care children, low-income parent caretakers, disabled adults, pregnant moms, and some other populations. Basically, most of the Medicaid program, besides dually eligibles, waiver populations, and individuals living in long-term care facilities. The Mississippi CAN contracts were procured through a competitive process in 2017 were effective July 1, 2017, and went operational on October 1st, 2018. 3 contractors are Molina, United Healthcare, and Magnolia Health Plan, the subsidiary of Centene. We are now in the next to last year of the Mississippi CAN contracts. And then I will note these contracts were originally for a maximum of 5 years, but through legislation passed last year, you authorized the Division of Medicaid to extend the length of the Mississippi CAN contracts for 1 additional year. We also contract with Molina and United Healthcare to provide services for the Children's Health Insurance Program, or CHIP. That includes about 40 to 50,000 children. Those contracts were competitively procured in 2018 and went live November 1, 2019. At the same time that the program is being administered, the CAN contracts that are currently being administered, the division has been in the midst of an active competitive procurement process for new Mississippi CAN and Mississippi CHIP contracts. With Medicaid managed care, we do feel like we're in what feels like a never-ending procurement loop. Development of this 2021 procurement began in 2020, barely a year after operational go live for Mississippi CAN, and just months after CHIP go live. For months, the agencies worked on preparing several 100-page model contract that federal authorities use as the guiding document of the managed care relationship. We sought out input from providers, beneficiaries, and other stakeholders on how to design a procurement that best meets the needs of the state and harnesses the full potential of a coordinated care delivery system. Now, since federal law requires actuaries to set managed care rates that are actuarially sound, an invitation for bid was not a suitable solicitation method. So as such, the division had to receive permission from the Public Procurement Review Board to conduct a request for qualifications. Now, getting permission for a request for proposals or request for qualifications, adds about 3 extra months to the procurement cycle. Just a request for qualifications is probably a term that's not familiar to everybody, but it's basically the same thing as a request for proposals, just that the price component is scored equally. So by December 2021, the division had released the competitive procurement for Medicaid managed care services. The general public and prospective vendors have already had an opportunity to object to the solicitation. No objections to that solicitation were made by the December 17th deadline. By January, any vendors who thought they might submit a proposal were required to submit letters of intent to the division. These letters of intent are just basically say that the prospective contractor may submit a proposal to the division when it's due. Proposals from those prospective contractors are due in less than 3 weeks on March 4th. And after proposals are submitted, the evaluation process begins. An evaluation committee is comprised of the Division of Medicaid staff and our contractors, and they're tasked with evaluating the merits of the eligible qualifications. The committee is approved by myself and includes members who have relevant experience in the Medicaid program. They will thoroughly review the proposals, which can be thousands of pages long. The evaluation committee also goes through a conflict certification process, a rigorous conflict certification process. And a maximum of 1,000 points will be available for each qualification. The points awarded per phase by the evaluation committee will be totaled to determine the points awarded for the entire proposal. Evaluation of eligible qualifications will be conducted in 3 stages. First, the division's Office of Procurement and their designees will complete stage 1. The evaluation committee will complete stage 2. And in stage 3, the Office of Procurement and its designees will compile the results of the evaluation and make a recommendation to the executive director based on the results of those evaluations. And at that point, a decision is made to proceed to award. So in stage 1, the division's Office of Procurement reviews each qualification to determine if it's responsive, if it's complete, if it complies with the instructions to the prospective contractors in the RFQ. Each qualification that is incomplete will be declared non-responsive, may be rejected with no further evaluation. A big part of this is working to ensure that these massive proposal submissions do not contain information that could identify the identities of the prospective vendor. And I want to talk about that blind evaluation process, a minute. The effort to ensure blind evaluation of the technical component of the procurement is a requirement of Public Procurement Review Board regulations that flow from the legislature's passage of House Bill 1109 in 2017. Chairman Polk can speak better to the intent than I can, but my recollection is that the legislature wanted to minimize bias in the procurement process and put more emphasis on the solutions the prospective vendors were offering, not their identities. Vendors are strictly warned to keep any identifying information, including company colors, out of the technical portion of the procurement. Following the instructions for blind evaluations is one of the perilous spots where procurements can go off the rails. I'm sure more than one agency can share a story of a lengthy procurement that had to be terminated because every vendor revealed some kind of identifying information about itself, even if it was as minor as a single isolated reference in the middle of a Gantt chart on page 102 of a several hundred-page proposal. Back in college, 99.9% would get you an A+, but in today's state government procurement environment, anything less than 100% correct can be deemed failure. Now, I'll admit I'm not an advocate of some of the rigid and cumbersome features of state procurement processes, but they are intended to be fair. In stage 2, the evaluation committee will review each offeror's qualifications to determine if the offeror or prospective contractor sufficiently addresses the requirements and has developed a specific approach to meeting each requirement. The evaluation committee evaluates the technical or unmarked portion and a management or marked or non-blind factors in 2 distinct rounds. During round 1, the evaluation committee reviews the technical factors. The management factors are reviewed in round 2. This ensures that the technical factors are reviewed blind, meaning that the evaluation committee will not be informed of the identity of the author of each qualification's technical factors. And during round 2, the evaluation committee is informed of the identity of the author of each qualification's management factors. The evaluation committee will use a consensus scoring method to award points in both the evaluation rounds. The evaluation committee will evaluate the technical and management factors in 2 distinct consensus scoring sessions, with 1 session occurring after each round's evaluation period is complete. Each member will independently evaluate each offeror's technical factors qualification, making his or her own notes about the strengths and weaknesses of the proposal. At the end of the round 1 evaluation period, the committee will convene to assign consensus scores to each offeror's technical factors qualification. And an independent facilitator will be used to conduct the consensus scoring. After the round 1 consensus scoring is completed, the technical factor qualification scores are locked and can no longer be changed by the evaluation committee. During round 2, The evaluation committee will review the management factors. Each member will independently evaluate each offeror's management factors qualification, making his or her own notes about the strengths and weaknesses of the offeror's proposal. And at the end of the round 2 evaluation period, the evaluation committee will convene to assign consensus scores to each offeror's management factors qualifications. An independent facilitator will be used there as well to conduct the consensus scoring. And after the round 2 consensus scoring is completed, the management factor qualification scores are locked and can no longer be changed by the evaluation committee. After the evaluation committee has completed the evaluation of the qualifications, a summary report, including all evaluations, will be submitted to me, and I will be making the final decision regarding the winning qualifications. And in making that final decision, this is more of a decision about, the number of vendors, not myself inserting my own preferences or conducting some independent review that would override the evaluation committee. The evaluation committee, does the scoring, and then we move forward from there. So after that, an agreed party has the right to file a protest with the division, or protest directly to the Public Procurement Review Board. We recommend that protesters seek resolution of their complaints initially with the division. Any actual or prospective offer that's aggrieved in connection with the solicitation, may protest to the chief procurement officer of the division, with a copy to the director of DFA. That protest has to be submitted in writing within 7 calendar days following the issuance of the notice of intent to award, or within 7 calendar days of the solicitation protest posting if the protest is based on the solicitation. But that phase is already passed with nobody protesting based on the solicitation. I will say this: a protest in any state Medicaid managed care procurement is a near certainty. You can look around the country and see the numerous procurement protests that have taken place. Louisiana had a procurement released in 2018 or 2019 that wound up being thrown out. And just a week ago, in February 2022, they announced awards for the re-procurement. And they still haven't gone through the protest period. Likewise, Kentucky Medicaid has had its procurement canceled twice since 2019. Florida Medicaid is already building up a war chest for a procurement protest or a procurement that hasn't even been released. Once contracts are awarded, the contractors can't just start getting capitation payments and paying providers. Implementation requires intense collaboration between the division and winning vendors to ensure that all information technology systems are compatible and running. Quality metrics are clear and sufficient investment has been made by the vendors to make them achievable. Vendors have the appropriate staff in place to ensure that members receive the services they've been promised. And this implementation period is a no-cost period of the contract. If we have a flawless procurement without a prolonged protest period, we expect to have contracts awarded in mid-2022, the implementation period through 2022, mid-2023, and an operational go-live date of July 1, 2023. So that's really where we are with the ongoing competitive procurement. I've said it, from here to Biloxi to Byhalia, we're committed to doing this procurement process, fairly, and selecting the firms who put forward the strongest proposals. The text of the Curry Amendment in House Bill 68 is hazardous. I mean, if passed, the amendment would subject 162,328 Medicaid beneficiaries to a hurried reassignment process that would disrupt care services. It likely would result in litigation against the Division of Medicaid, and it could restrict the pool of vendors beyond the one company mentioned in the Florida Bay. And those are just some of the potential negative impacts from the first paragraph. I think you read the language, Chairman Blackwell, and I think it's important that to mention that that amendment doesn't just apply to Mississippi settlements. It applies to settlements in any other state as well. So in looking at that, that prompted us to try to ascertain whether other managed care entities had executed settlement agreements of over $50 million, that were related to overpayments in the state's Medicaid program. Good Jobs First, the National Policy Resources Center, has built a violation tracker database that includes information about cases resolved by federal agencies in the last 20 years, plus cases for state AGs and selected, state regulatory agencies. The federal settlements, we didn't look at because those were not addressed in the amendment, but we went to the Good Jobs First violation tracker to, trying to ascertain the breadth. We picked the 6 Fortune 200 companies that had Medicaid managed care business, that being CVS, United, Anthem, Centene, Humana, and Molina. And potentially 3 of the 6, Centene, Anthem, and United, could be excluded from Medicaid managed care in Mississippi based on this amendment's criteria. Anthem would be impacted because Amerigroup, a Medicaid managed care subsidiary of Anthem, executed a settlement of over $50 million around 2008 with the Illinois Attorney General's office. United Healthcare also may be impacted by a 2009 settlement in the state of New York. Now, I do not have Andrew Cuomo and Lisa Madigan on speed dial, so I don't know the details of those settlements from that time period. Before I was a recovering attorney, I was a real attorney, and I worked with some large corporations in complex civil litigation matters. And for them, settling a civil lawsuit wasn't an admission of wrongdoing or a result of wrongdoing. It was just numbers on a piece of paper. And using past corporate civil settlements, whether it was 1 year ago or 15 years ago, to steer contracting decisions seems irresponsible. If the amendment only applied to the stated target, it still presents huge logistical and operational problems for the division. To terminate any Medicaid managed care contractor in an orderly fashion, the division needs no less than 90 days. Under this amendment, which is effective upon passage, the division would have to stop making capitated payments immediately, which, depending on the effective date, could leave the division with as little as a couple of days to reassign 162,000 members presently enrolled with Magnolia. Federal regulations require that members be able to choose their managed care plans, so a special open enrollment period would need to be established. There are serious questions about the resolution of pending member appeals, pending provider appeals. It would impact care continuity, and providers contracted with Centene may not be in-network providers with Molina or United. Providers who were reimbursed more by Centene may be reimbursed less by the other plans. Members would be separated from care managers, and people would lose their jobs. And my hunch is that the impact would not be felt as much as the executive level as it would from customer service representatives and care coordinators that are employed through the local health plan. Unwinding one of these relationships is fraught with difficulty, even in a regular turnover phase that's specified in the contract. There's IT systems lifts, complications with financial reporting, and here, does it jeopardize potential risk corridor recoveries, directed payments to hospitals? Look, I don't think we've even begun to scratch the surface of the operational challenges that an amendment like this would present to the Medicaid program, and particularly the beneficiaries. The second paragraph, it appears to authorize the division to contract seemingly indefinitely with incumbent vendors who had contracts with the division in effect on January 1, 2022, and then mandates the division select a Mississippi nonprofit corporation. I will say that a Mississippi nonprofit corporation could be selected in the current active procurement, assuming there is a nonprofit corporation that submitted a letter of intent and submits a proposal by the March deadline and scores high enough. A few years ago, after the procurement was, after the 2017 procurement was completed and contracts were awarded, there was a legislative effort to require, the procurement be redone. Language passed in the House, was killed in the Senate. I do think this language certainly could come across as an effort to bypass competitive procurement altogether and set government contractors through statute. I think that's I think that about covers it, and I'm happy to answer any questions.
Thank you. Could you maybe explain a little bit about managed care, when we started with the managed care program here in the state, and then any perspective nationally on managed care and with the Medicaid program?
Sure. I think the program, we're about 10 years into the program, and initially it started with just I believe the disabled adult population, about 55,000 members, and by 2012, foster children, low-income parent caretakers, were added in, and then in 2014, the non-disabled children, which is probably the largest group, were also added in. Pregnant moms were, I believe, in 2012. I'll have to go back and check. We have inpatient hospital was rolled in December 2015. For the last 4 years or so, the populations that are covered in managed care have been in Mississippi have been relatively stable. It can get up to about 2/3 of the total Medicaid population, just based on who is in the particular rate cells at the time. I think there are about 40 states that are using a managed care delivery system, maybe a little bit more than that, but the notable large states that aren't, Alabama, Connecticut, Oklahoma, but that's being debated. And then you have some of your smaller, frontier states. Wyoming doesn't have managed care. I don't believe Alaska does. Maine does not. It's pretty prevalent. It's become pretty prevalent across the country, particularly after the Affordable Care Act. I think there are a lot of drivers, but one of them being that there is more flexibility. The federal authorities do give more flexibility in the managed care program for directed payments and those types of some things that might not, were you still subject to federal UPL requirements under fee for service that you might not get to do. So it's it's part care coordination, it's part financing, but yeah, it is the prevalent delivery system model in the country right now.
Thank you. I've got a few questions. A number of, actually, you addressed a few of my questions in your statement. So I apologize if I am repetitive with it. Let me just go through the blind process. So you don't know who applies for the contracts?
I don't know.
Would you know if they were a non-for-profit or for-profit corporation?
The evaluation committee would not know that until I don't think they would know that until the management factor, in the unblind phase of the procurement.
If an identifying indicator for one of these companies were to come up, and you mentioned one time, and somebody had mentioned it on page 102 or something of a application, does that disqualify that applicant, or does the process start over again? So if you know the identity of one of the applicants, how do you handle that?
Look, I am not I'm by no means the Medicaid expert on that might be better for that might be a better question for DFA and the subject matter experts on the PPRB, because those are the types of, that's the type of guidance that they're able to provide. But there have been instances where when there's identifying information, there's definitions of identifying information that are set out in the solicitation document, that those vendors were disqualified.
In the first paragraph of the amendment, it talks about $500 million or $50 million settlement. To your knowledge, how often are there settlements with the state Medicaid program from a managed care company?
I'm not sure.
I mean, are there other states that are receiving settlements?
Yes. Yeah. I think in the recent one in Mississippi, there were settlements and related settlements in other states. I mean, it was more kind of a national AG. It wasn't a Mississippi specific settlement, even though I guess the agreement was executed between the Attorney General and the contractor.
So I think you mentioned United has made settlements in the past. And so if this amendment were to be adopted, would the program have a challenge in finding providers? A managed care company?
It's not a really large pool already. There's been a lot of consolidation. And there are small managed care companies that are out there that are in certain markets. I don't know how Mississippi's not always the first place that these companies look to locate. You look at California. I think their Medi-Cal RFP came out this week or last week, and you get a lot of interest there. I think we had 7 bidders in 2017, and I think that's the most the program has ever had. We don't have long-term services and supports in managed care. That probably causes some to lose interest. So it's already not a very not a very large pool.
I think you went through some of the consequences if we were to eliminate a provider or managed care company. How would the process work normally? Let's say we're going through this process and you pick your 3 vendors and one of them is different from the current 3. How does that, can you walk us through that transition?
That's what happened in 2017, because at the time we had 2. And then we went from 2 to 3. Molina came in. It slows down the implementation process a little bit because there's somebody that's new to the program. So there are those IT, we could have another hearing with somebody else from Medicaid that can talk about some of the data submission that comes around encounters and quality measures. And you've got to get the IT systems to work and understand how the reporting requirements and the expectations for the types of data and information that the division wants and expects, how that comes through. Getting all of the different criteria, and plans that under federal rules, we have to pre-approve a lot of the information that the managed care plans send out. It's honestly, it's probably too much, but that's a conversation for another day. But there's a lot of paperwork that goes in, and as I mentioned earlier, with the making certain that there are enough state resources to provide services, and that members can. The tricky part, I guess, comes with the assignment methodology, with assigning members, because the systems have to change to be able to. We have this auto assignment methodology, and then you've got to put a new. You have to put a new plan in, and there's a lot to that. Trying to make sure that family members stay together, making sure you can link people to the PCP that's in network, those types of things. So it's a really, that implementation period, probably doesn't get as much attention, but it's really important to do it right and be thorough so you can set a good course for the operational period of the contract.
So it'd be safe to say it's a challenge. Even a plan change of vendors is a challenge. So an abrupt change, as you mentioned, would have severe consequences to both patients and providers. Is that correct?
Yes.
In your application process, are there any questions that might indicate if a provider has settled in the past with another state?
I don't know. I would have to go back and look at the solicitation document.
Would that be a question that would have value in the determination process?
Well, I was hoping I wouldn't have to get to the point where I had to say we start to get a little too far into the details of the active procurement and my impressions of questions and what might be a good response or anything like that. I don't want to feel like we certainly aren't trying to send signals to anybody. So. I'll just have to pass on.
I understand. I'm going to open up the questioning to other members of the committee, but would just like to remind the members that this subject matter has to do with the procurement process, not an individual company. So if you could keep your questions in kind of that format. And the director may or may not be able to answer some of these questions because of the nature of the fact that we are in that procurement process right now. So I'll open it up. Senator Wiggins.
Thank you, Mr. Chairman. Thank you for having this hearing. I don't think you have to worry about me getting involved in state procurement law after hearing all that. But no. Director Snyder, I appreciate you bringing up what I would call some of the historical context, because that's where I wanted to go with this. and you mentioned other states, but you served on what was called the the Managed Care Task Force a couple years ago. Is that right?
All right, the commission on expanding long-term care, yeah, I can't remember. Yes.
Okay, and that task force had a lot of people on, or a number of people on it, and made a report, correct?
Correct,
It was presented to the legislature, right?
correct,
And in that report, it detailed all the states that do managed care and the states that don't do managed care. Is that right?
correct.
In fact, it shows what all the states do and how managed care came to be across this country, right?
That's right.
And it gave recommendations of going forward, what to do and what not to do. Is that right?
That's right.
Okay. And that was actually put out on the legislature's website, was it not?
It was.
So at least 3 years ago, all that information was available to the public, correct?
Correct.
And that managed care task force was actually built on a task force that was put by Public Health Chairman Alan Nunley back in the early 2000s. Is that right? If you recall.
I don't recall.
Okay. Well, I'll tell you it was because it's actually mentioned in the report. Now, you weren't director certainly in 2000, right?
I was a sophomore at Ole Miss in 2000.
Okay. And the statute that governs, the law that governs managed care in this state was passed by legislatures before you were director, right?
That's correct.
And it was actually passed before, I think many of these people were in the legislature, right?
Correct.
Okay. So managed care is not a new thing.
It's not.
Okay. So from what you know, back then, why was managed care of Medicaid an issue and why did it get put into statute?
My understanding is that the state budget was a large problem, and there was definitely a feeling that with better utilization management techniques and care coordination practices, the growth of medical spending could slow, and also that this model, there are a lot of restrictions in a regular state program. There's the flexibility of managed care. There's more flexibility than there is for a fee-for-service program, and that services could be delivered more effectively with more flexibility. I'm sure there are a number of other reasons, but
and I know that was before your time, but costs continued to rise, correct?
yes,
And it created budget instability within the state of Mississippi, as far as you know, right? Or it helps create budget predictability.
yeah, it certainly helps create budget predictability.
Right? And how much is the state budget, state alone, and then state and federal together, just last year for the Division of Medicaid?
The state support appropriation was a little under 900 million. There are some other some other sources of non-federal share, provider assessments, some contributions from Department of Mental Health, Department of Rehab for some of their services, but that usually runs around, the non-federal share is 1.2, 1.4 billion with a total spend of about 6.5 billion. It's a lot of those numbers have shifted a little bit with the 17% enrollment growth following the continuous coverage requirement in the 2020.
Because traditionally Medicaid fluctuates depending on who comes onto the rolls year over year.
That's
correct?
Right.
Okay. And even when you took over as director, there was a continual rise in budget deficits in the Division of Medicaid. Is that right? Before you took over as
Before
director.
I took over.
Yeah. And since you've taken over, working in your capacity, the budget deficits, at least for the last 3 years, are no more. And you've had a level funding to a degree. Is that right?
We have not had a state support budget deficit since 2018. So we'll be on our fourth, let's see, our fourth year without a state support budget deficit.
Okay. And when my recollection is when you took over as director, there were only 2 managed care companies, correct? In Medicaid.
I think Molina had been awarded the contract at that point, the third, and but operational go live was still about 10 months away. So there were 2, but going to 3.
Okay. And the statute that governs this part, the managed care, actually allows for many different types of managed care companies. Is that correct? And when I say that, I mean like a provider sponsored plan, an HMO type plan. That allows for that, correct?
That's right.
And so when you put your procurement out, you say, this is what we want, and people come in and let us hear what you got, and then you make the decisions under the laws that you talked about. Is that right?
That's correct.
Okay. So you mentioned, if I got your quote right, across the country, it's a near certainty that there's a protest.
Oh, yeah.
You said that. And and I don't want to put words in your mouth, but I would say the near certainty is because there's so much money involved.
When did you get this concern about putting words?
I realize that's a secondary concern, Senator Bryan. The protests come as a result because there's so much money involved, correct?
Correct.
So no matter what decision gets decided, there's going to be a protest.
Most likely.
And then that tends to spill over into the legislature when those protests either don't happen or they don't go their way.
That happened last time.
Okay.
Yes.
Because if the protests don't work, we're going to go change the law, right? Is what tends to happen.
That happened. Yeah, that did happen in 2018.
Okay. Thank you, Mr. Chairman. Appreciate it.
Thank you, Mr. Chairman, and thank you, Mr. Snyder. A couple of questions. You said in the procurement process that there would be at least 2, but no more than 3 vendors chosen. And is that 2 or 3 decision yours, or is that part of a committee's decision?
That would be the executive director's decision.
Okay, and what would you base that decision on? Could you share with us some of the factors as to whether it's better to have 2 or 3? Is that the consideration, or is it just the scoring mechanism that you use or methodology is so close that it would be unfair to exclude the third one because their score was almost the same as the first 2?
Lawyer advised me not to answer that one.
Okay, let me ask it a different way. What factors will you take into consideration when determining the number of vendors that will ultimately be chosen?
Look, I think federal regulations require that members have a choice of managed care entities when you're under one of these state plan managed care programs. So, I think ensuring that there's that adequate access to choice is always is always top of mind in a decision. Actuarial soundness. I think another way to answer this is the reason that we did 3 but not 4 was because when you start to calculate the rates and the administrative costs and that type of thing, the actuary in 2017 found that having 4 managed care plans would not be efficient and actuarially sound. So that cost consideration on administrative expenses and those types of things also comes in. It's why we don't have yeah, I think that might be a big reason that we're not one of these application states where there are 14 managed care plans and some that have, 1,800 people. Somebody's got to, there are a lot of responsibilities that come with, oversight of different entities, and, providers have to contract with different plans. So, it's a whole host of factors in looking at those numbers.
Do you think there's any bias built into the process, certainly unintended, but nonetheless, for newer companies versus long-established companies in this field?
I think every effort is made to be fair in the process. It's a test, and like any test, is it the does it ask the right things to get what you're trying to seek? I mean, does the ACT measure intelligence, or does it measure how you take the ACT? Maybe it depends on how well you did on it, but I think we certainly don't. We certainly make every effort to be fair.
Sure. Does Medicaid have a position on no bid contracts? Are they good, they bad, problematic, or helpful?
Look, I think competition is healthy. I also, if the procurement process takes 5 years and leads to, I don't think we have to think a lot about, and this may be inapplicable here because their price isn't a component. The actuary is setting the rates. But in some contexts, trying to get the best value, like we're looking to get the best value for the taxpayer. Personally, I don't think we should have to competitively bid attorneys. Lowest is
Senator Polk liked that answer.
but I think I do think there are a lot of problems with obviously with single source and no bid arrangements, but I think you also have to consider things in context and the type of services, and it's a myriad of factors that go into that.
Has Mississippi gotten into trouble in the past with no bid contracts? Are you, in your experience?
I know that the former commissioner of corrections did. I was involved in the I was worked on that task force that Andy Taggart and Bill Crawford and Constance Slaughter Harvey and Judge Gibbs participated in, and have been around to see the efforts to make a more open and accountable procurement system.
Has the population of Medicaid managed care gone up or down recently, and specifically due to the pandemic?
What do you mean by recently?
In the last 3 years?
It's fluctuated. Currently, it's probably lower than it was when I was first director, but it's gotten up over 500,000 at some points, and it just fluctuates depending. The public health emergency has caused some fluctuations in some different directions. So, but once we're out of the public health emergency, it probably will, unless Congress has throws us for another loop, it should be pretty stable.
Okay. My final question, do you believe that the managed care process in Mississippi has been a net positive or a net negative, and why?
I don't think I don't think we could finance the healthcare system in the state without it. So, yeah, I think that alone probably outweighs some of the negatives that people may cite about the managed care program.
Thank you. Thanks, Mr. Chairman.
Senator Bryant.
I think I understood the chair to say we would have questions about the procurement process. And so if it weren't for that, I would ask some question about why it is we always have this endless discussion about the cost of the Medicaid program, and no one ever even seems to worry about whether we are alleviating human suffering and whether the people of the state can get health care just like every industrialized world in the country except this one. But back to the procurement process. I listened to your explanation of the procurement process. I looked around for bamboo shoots to nail under my thumbnails while you were doing that as an alternative. How much of that is required by state law, and how much of that is required by federal law?
Those are a large portion of the procedural parts of the mechanisms of the procurement would be required by state law. There are some of the readiness requirement, the implementation, some of the things there would be required by federal law. The contract itself is very driven by federal requirements more so than state preferences about what goes in.
What if the state law, what if we just repealed every procurement rule, every board, every thingy, all of it, just got rid of the bid laws, got rid of all of it, and simply said the agency director is authorized to enter into contracts? Can we do that under federal law?
I think with certain services, they require competition, recovery. I think maybe our external quality reviewer has to go through a competitive process. Some of it depends on whether you get enhanced match or not, that it has to be competitive. I may walk out of here and one of the attorneys tells me there's a CFR that says exactly what.
I'm convinced there's a CFR that says everything. But I mean, I'm not being flip, and this isn't the only area between all these boards and procurement processes and the state personnel board and everything. We've got ourselves tied in such knots that state government can't function. I'm ready to go back to the spoil system.
Yeah, look, you're preaching to the choir. There's
Well, the choir needs to hear a good sermon too every now and again.
But look, the bureaucratic inertia and the red tape that government places on itself is probably the largest frustration I have with our job. Like how difficult it is to just take a step forward because it's taxpayer money, so there need to be checks and controls in place. But at some point it gets to be so cumbersome that that work in elevating quality and innovation, it's near impossible. So I think part of that, and part of the reason for a shift to make things so much tighter is the spoil system or this flexibility was abused by a few bad actors. And as a result, the honest, straightforward, good civil servants are the ones being punished, and ultimately it in some ways how slow it is, it drives up transactional costs. It deters the number of people that are interested in doing business with the state, and may actually hurt taxpayers in the long run.
Thank you.
Thank you, Mr. Chairman. Thank you, Drew, for being here. I'm a non-attorney, so I'm not going to ask a question that I know the answer to, but Did you say that, how many people are, current? You said 162,000 under Centene?
Correct.
All right. And then how many under Molina and United? Do you know those offhand?
I don't know offhand. United is, Centene's the largest within the Mississippi CAN program. United has the most number of Mississippi CAN and CHIP covered lives. Molina is slightly over 100,000, I think, with Medicaid and CHIP.
Okay. And if I heard you correctly, based on this amendment, would United be canceled at the same time as well?
Well, I think what would happen is there would be, you'd have to go back to this, this case from settlement from 12 years ago and get into the details. And was it, now I think it was 50 million. It wasn't, and the statute said over 50 million. So, we would get into this there would end up being this ambiguity about, is United covered or are they not? And when there's a prohibition against making capitated payments, and there's a lot of capitated payments being made, you don't want to make, that's a pretty big mistake to make. And the question, do we really need to be, getting into this hair splitting about if some settlement that happened over a decade ago trigger about, reimbursement rates, across multiple programs, does that trigger some kind of expulsion from the Mississippi Medicaid program of the largest vendors?
Well, I guess what I was wondering is, based on what you said, could there possibly be a situation where United would be canceled by this language, and then you would have an additional 100,000+ people you'd have to move on top of the 162,000 with Centene?
Yeah. Yes. And look, if there were two, we're really we're immediately out of compliance with federal regulations, because they're very clear. You got to have a choice of two. So, that presents, an even larger problem. And even, that would, unworkable.
Okay. I guess this may be a question that, this is about the bill, so I don't know if this is the proper venue, but my question would be, and it may be for the Attorney General's office on the settlement, is this complicating issues with the settlement agreement reached with the state? I don't know what the settlement agreement was. When was the actual settlement agreement reached?
Sometime last year. Look, I would say any questions about the settlement, representatives from the AG's office or Paul Hurst or one of the listed attendees, the plaintiffs' firms that represented them in this, they would be the people to ask those questions.
Okay. And my other question, I think Senator Filligan asked, just overall on managed care. You said it's been 10 years. I think that's kind of the question that I had is your thoughts on, are we better off today than we were 10 years ago with managed care? Is it helping, outcomes, or what is your overall view on, and you kind of answered it. So unless you want to expand on it, I think you kind of answered the question, but I know it's difficult. You got a pretty difficult job to have to say grace over. So thank you for being here.
Thank you, Mr. Chairman. Thank you, Mr. Snyder. I appreciate your detailed explanation of this very complex process that must have taken up a lot of your time and a lot of your staff time. And I understand that we started this so that we could provide faster, more efficient and service and be more flexible. Is that right? That the whole point of what this exercise was that we would take advantage of the efficiencies and flexibility of the private sector. And that's why you've been on this conveyor belt for the last 10 years. It just seems to me, and so to follow up on Senator Brown's question, how much of this intense, complicated work where 99.9% can get you in trouble is due to state law? And whether we can change that here in the legislature or due to federal requirements?
Mostly, overwhelmingly state law.
And so a lot of the time and the litigation that may result is a result of what this legislature has done, not because of the federal requirements. And so we really ought to.
I think some of it's statutory. I think some of it is regulatory that's interpreted as being based in a statutory requirement. So yeah, it's a mix of state statute and administrative rules.
Well, I think we would welcome your suggestions on what the legislature can do to state law that could make this more efficient. Because it seems to me that once we decided to embark on this managed care process, that you've just been on a conveyor belt ever since. It won't stop. And you're developing proposals for the next proposal while you're grading the last proposal. And I hear you saying almost that once you get selected, it's almost impossible to disengage. Is that fair to say?
No, I don't think so. Look, the chip procurement, a good example, 2 years ago, United and Centene were the incumbents. Another competitive procurement, Centene, was out, Molina was in. So, it was somebody that was already in the program at the time, but under ordinary conditions where a turnover plan can be deployed and there's the proper amount of planning, and usually it's long in advance that somebody would know that they're moving out and somebody else is moving in, so you can do those transitions. So I wouldn't say I wouldn't say it's hard to it's tough, but it's doable, and it's happened here and it happens in other states.
Okay. So other than the suggestions that you might have, which I think we'd all like to see on how to make what we can do to make the process more efficient, what does the legislature have to do this year, if anything? If the legislature does nothing, would your process just continue and you'll go through the process and select somebody, or what is required, if anything, for us to do this year?
Related to managed care?
Yes.
Fix the rate freeze, and that's about it.
Mm-hmm. And what is the status of the current contracts that are in place, and when do they expire?
They expire June 30 of 2022.
Right.
And they were effective July 1, 2017. Then operational go live. And when I say operational go live, that means when they start getting capitation payments. I think that was October 1 of 2018.
Okay, great. Thank you very much. Thank you, Mr. Chairman.
Any other members' questions? I've just got one more, in my short time here, I've come to understand that sometimes as we go through and make legislation that we think something looks real good, and then once it gets operationalized, we realize the unintended consequences that we caused. If this amendment were to be adopted, the language that's in it, would it be a precedent for other, would it apply to other industries and maybe other businesses that might want to come and settle here in the state in terms of having settled or having a lawsuit or something like that?
The way we're interpreting I think there's there is enough of an open question that there could be a problem, and there are other vendors outside the managed care space, both in the Medicaid program and in other programs, some Medicaid providers that have had settlements that would trigger over that $50 million threshold. I don't think, I would say though, that this is limited to managed care contractors, because it says the services provided under 4313-117H, and I think that's referring to managed care. So now does it set a there's always is it a slippery slope, and do we start to look at Microsoft had a big settlement with General Hood in 2009. Do they need to, do we, is Microsoft, or is Microsoft Word going away? I mean, realistically, that's not going to happen, but yet I think it's, sometimes, ideas like this, it's not the beginning and the end, and things tend to grow.
Anything else from any committee members? All right. Thank you, Drew. We appreciate you.
Are we about to, excuse me, are we about to finish?
Yes, sir.
Or-
Have another question?
I do.
Go ahead.
Or whatever. If what we're talking about is this amendment, it seems there are two parts to the amendment. One effectively deals with Centene, although I assume in an attempt to comply with law, they did not put any identifying markers on it so that we could tell it was Centene they were talking about. But it also effectively applies to the hospital plan. And I have said on a number of occasions that the Hospital Association and a group of hospitals, whoever it is, has put together a plan to have a managed care plan. Their argument is we can do this better and cheaper than the for-profit guys. And I don't know if you're aware of this or not, but a lot of us get a lot of complaints from hospitals and other providers about managed care. I don't know if you've encountered that or not. But if the people who are complaining are willing to say, we'll take this on and we'll do it, and we'll show you we can do this better than the other guys, and we can show you that all those complaints we're making about them are right, and we'll do it better. And why wouldn't we want to call their bluff and put a provider managed plan into effect? You've got for-profit plans, you have this nonprofit provider plan, see if they can do it. I'm not sure that they can, but it'd be interesting to watch, and it would sure answer a lot of questions, because if they cannot function, then maybe all this stuff they're telling us about the shortcomings of the existing plans might have a yes, but to it. But if they can pull it off, then the question is, well, why don't we do that? It just seems to me like a good experiment to run. Why don't we do that?
I will tell you this: we've got a competitive process that is ongoing, that's open. That if they've submitted proposals are due March 4th. So.
Well, I'll say this about that. You were talking about hiring lawyers and having bids for them. Clearly, you need a competent lawyer. And in some cases, you need a super competent lawyer. But it's my understanding that once upon a time, there were fixed rates for bond bills. And you hire lawyers when you issue bonds. And the state started taking into account the amount of money that the lawyers were charging in fees. There's no longer a fixed rate. And the legal fees plummeted. And the bonds were issued. I mean, the question is, can you handle this and get the bonds sold for us? And if you could do that, that's what we're paying you to do. And I think some lawyer muttered to me once that the fees on general obligation bonds for the state had gotten so low that they were almost indifferent as to whether they got the contract or not. And I thought, well, that is the theory behind all of this, is that you reach that point with a competitive process. So I think there are two questions. One is, are you competent to do this? And we've got 6 applicants. And we look at the 6 applicants and say, yeah, each one of these 6 people could run this program. And yeah, there's some differences, and this one looks a little bit better than that one. But by and large, 6 of them look pretty much competent to do it. If you get to that point, and then the hospital provider plan is one of those 6, it seems to me that there's something to be said for giving them a shot at it if they reach that threshold, simply because they're different than the other 5. So instead of going through this esoteric process to see whether in theory they score 1, 2, 3, 4, 5, 6, again, to use the legal analogy, if they're lawyers from Virginia, you know, they're all pretty good.
Any other members? Thank you. Drew, again, thank you. For the committee members, I hope this has given you some information to think about prior to our next committee meeting. We're adjourned. Thank you.